Welcome to my series, Back to the Basics of Employment Law. I'm Patricia Gonzalez, an employment lawyer at Parley McLaws. I act for both employers and employees for a variety of employment matters. Today I want to talk about a concept that comes up quite often in my practice, and that's constructive dismissal. Constructive dismissal is a situation where an employer makes a unilateral, fundamental, and detrimental change to a term or condition of an employee's employment without providing reasonable notice of that change. When this occurs, the employee can treat the contract as wrongfully terminated and resign, and the employer will be responsible for damages in lieu of reasonable notice. It's important to note that minor changes to a term or condition of employment will not be enough to establish constructive dismissal. Also, the employee has the burden of proving that the employer's actions have resulted in a constructive dismissal. If the employee quits on the basis that he or she has been constructively dismissed, but fails to prove that at court, he or she will be treated as having resigned. The situations that will give rise to constructive dismissal vary widely, and it's not possible to list all the situations that will be considered a constructive dismissal. But they typically involve the following negative changes to the employee's status or reporting functions, such as a demotion, job duties or work conditions, such as changing the employee's hours or work tasks, compensation changes, such as a significant pay cut or changes to the benefits or bonus structure, or imposing a layoff or a suspension when the employer does not have the right set out in the employment agreement to do so. Even the existence of a hostile work environment can also trigger a constructive dismissal. The analysis of whether a situation is a constructive dismissal requires a thorough understanding of the facts and case law, as subtle differences in facts can have opposite results. For example, a 5% reduction in base pay may not be enough on its own to classify as a constructive dismissal, but a 5% reduction in base pay and detrimental changes to a bonus plan might. That is why employers who are considering making changes to employment terms and conditions should reach out to an employment lawyer beforehand to avoid inadvertently exposing itself to a constructive dismissal claim, as they will want to avoid legal costs to defend such a claim and the risk of obtaining a damage award against them. Even employers who are not making changes or facing constructive dismissal claim may want to contact an employment lawyer to discuss contractual provisions that can shield the employer from some constructive dismissal claims or limit the amount of damages to be paid when a claim takes place. Lastly, employers facing a constructive dismissal claim need to contact an employment lawyer, as there may be defenses that can be successfully raised. Now, employees who are worried that they are experiencing a constructive dismissal also need to talk to an experienced employment lawyer before taking any action that may prove harmful to his or her legal position. For example, if an employee has experienced a detrimental change to his or her employment and does not respond quickly to those changes, they may be found to have agreed to those changes, thereby foregoing a potential constructive dismissal claim. Please do not hesitate to reach out to me or the employment team at Parley McLaws if you need help with any employment matter.